G'day, I'm Stephen Page from Page Provan Family and Fertility Lawyers, and I'm talking today about surrogacy in Queensland. The Queensland Surrogacy Act was enacted in 2010, and it says anyone, if they're single or a couple, can access surrogacy. Surrogacy must be altruistic, and it's a criminal offence to enter into a commercial surrogacy arrangement. It's also a criminal offence to advertise to the public about surrogacy. It's a criminal offence to make payment under a commercial surrogacy arrangement. And these offences, and it's also an offence, I should say, in effect, for a doctor to provide service to a commercial surrogate before she's pregnant. After she's pregnant, it doesn't matter. And these offences also apply overseas. They're quite specific if it's done by someone who is ordinarily resident in Queensland. I'm a dad through surrogacy in Queensland, and it's a complex process. And if you want the easiest armchair guide, get my book. We're Not If, Surrogacy for Australians. And in that book, it's chapter 23, it's entitled Surrogacy in Queensland. And at the beginning, we have a mud map, a timeline with all the moving parts about what needs to be done. But in essence, you've got 2, 3, 4 things that are vital. Most surrogacy happens via IVF. So you could have an at-home insemination, and I've got clients who've done that, but most of the time it'll be via IVF. So first step is create an embryo. So you've got to be very careful about how you do that in terms of what you get charged by clinics, because they have different rules about how they apply certain laws. So it's a bit of a lottery. But the quality of IVF, I should say, in Queensland, like the rest of Australia, is very, very, very high. We should be very proud of our IVF clinics. And I don't say that because I'm a director of the Fertility Society of Australia and New Zealand, which I am. I don't say that because I've got some interest in IVF clinics. I don't have no financial interest in IVF clinics. I say that because that's what the evidence demonstrates. And backed up for what it's worth by my own journey. Once you've created the embryo, then you're right to rock and roll, and what you've got to do is have a written surrogacy arrangement. And both the intended parents, the surrogate and the surrogate's partner, and the jargon for the surrogate is birth mother. So you can have a minimum of 2 people, 1 intended parent and the surrogate, and a maximum of 4 people who sign up to the deal. And there are 2 or 3 things that have to happen before the surrogacy arrangement is signed up. Number 1, check out that your surrogate is actually okay to carry, so that's a medical check. Number 2, both sides get lawyers, the surrogate and partner on one side, the intended parents on the other. And we've acted, my firm has acted in many cases for intended parents and from time to time for surrogates. It's always a privilege either side. And then the third thing is to go off and get counselling. And so there are specialist counsellors who deal with that, typically someone who is an Australia New Zealand Infertility Counsellors Association member, an NZCA member. And with those steps in place, then and a favourable counselling report, then sign the surrogacy arrangement. Both lawyers then give legal clearance to the clinic. The clinic goes through its processes to approve the surrogacy arrangement, and that varies clinic to clinic. Some are more formal, some are less formal. Depends on who it is. There are 24 IVF clinics in Queensland, but when we boil it down to it, there are about 4 or 5 that do surrogacy, because most of those individual IVF units are actually part of a chain. And once they approve, then at the other end, then the pregnancy hopefully happens quickly, and at the other end, a child is born. So one of the things you've got to look at the beginning are the obvious, and that is to make sure that you know how your surrogate is giving birth. Is she going to be giving birth in a private hospital, as a private patient, or a public patient? If she's a private patient, then the intended parents pay for it, or they obtain maternity cover for her. Maternity cover has to be obtained 12 months before the birth. If it's a public patient, well, she's got to live within the catchment of that hospital. Is it safe? If she's living in the outback, then she's got to move to somewhere where it's close to the hospital early enough in the pregnancy that the risk to the child and her own health is minimal. After the birth of the child, then at that point, and I should say, sorry, I missed, there should be life insurance and there should be income protection insurance to cover the surrogate, just in case. And wills need to be done to make sure that the child doesn't inherit. If the surrogate is married but separated, then divorce needs to happen. Unless, and I've had this happen once, the surrogate's spouse is also a party to the surrogacy arrangement. As you can imagine, I don't recommend that ordinarily because it's risky. They could change their mind. They're not invested in the process, and then hold everyone else to ransom. Then when the child is born, the surrogate and partner are recognised as the parents, but the intended parents can name the child as theirs, and then 1 to 6 months post-birth, an application is made to the Children's Court of Queensland, so that's a district court level judge, to obtain a transfer of parentage. Now, there are something like 19 requirements under the legislation. There's a huge list, and the legislation is unique in Australia in setting out, here are the affidavits we need. As one judge said to me when I said that a deponent wasn't available to do an affidavit, Mr. Page, Parliament said must. Must means must. Well, of course I listened. The problem was that I had an uncooperative witness who was then faced with a subpoena, and, well, you don't have to turn up if you execute the affidavit. She executed the affidavit. Then you have an appearance, it's before a judge, and you have to go, and these days we bring the babies and we have photos in court, which is typically it's a 5 or 10 minute appearance, but you're in line with other matters that day, which are typically juveniles who are in trouble. Some judges deal with it at the beginning of the day. Some say, well, you've got to wait for those in custody. That's more important than the baby outside. It's up to the individual judge. They're mainly dealt with in Brisbane, but I'm aware of orders being made in Maroochydore, and we've also had orders made in Cairns and Townsville, for example. So it's wherever a district court judge has also got children's court, and where everyone can get to. There can be an appearance by phone if needed. And when the order is made, you are the parents, or the intended parents are the parents at that point. The surrogate and her husband are not. It's in case of filling out a form for births, deaths and marriages if the child is born in Queensland, because it may be a child born interstate. And births, deaths and marriages in Queensland are really efficient. Typically from when the order is pronounced to when the birth register is altered, so you get the new birth certificate, is 7 days. So that's it in a nutshell. I really support surrogacy in Queensland. It's been a privilege to have acted for intended parents and surrogates going through the domestic process starting in 2010. And it had its ups and downs for me, which you'll see in our videos, but also my book about my own surrogacy journey with my husband that resulted in my daughter, who is now 5. So go and have a look at the book. If you want a potted version, I'll give you lots of other helpful tips about surrogacy. But otherwise, that's the process in surrogacy, about surrogacy in Queensland. Thank you. Stephen Page from Page Provan Family and Fertility Lawyers.